Well, this afternoon, Bryan Kohberger will appear in a courtroom in Idaho in a hearing that may change his defense. He's charged in the murders of 4 University of Idaho students in November of last year, and his attorneys have argued he was driving alone on the night of the murders, something he did often. The defense plans to argue 2 motions at a hearing this afternoon that may have a big impact on the outcome of his upcoming murder trial. Criminal defense attorney and former prosecutor Joshua Ritter joins us now. He's also the host of the True Crime Daily Sidebar podcast. Joshua, always great to see you. So to start, what motion is the defense expected to argue this afternoon?
A couple of things, actually a few things. One, it's going to have to do with alibi. We've heard talk about how they're going to have to disclose evidence regarding what their alibi is. It's not traditionally the idea that we usually think of when we think of an alibi, but the other has to do with DNA and what the prosecution has to turn over. And that's probably the far more important motion, because what the defense is saying is that, listen, you've told us how that you have arrived at this conclusion. In other words, you've arrived at the idea that you believe our client's DNA was found at the crime scene. We want to know how. It's important for us to know how you got there. What mechanisms did you use? Where did it lead you? Did it lead you to other possible suspects? We need all of that information. The prosecution maintains that's not what's really important here. What's really important is that we did arrive at the idea that we were able to match your client to evidence found at the crime scene, and the how that we got there is not relevant, and therefore not something that we're necessarily going to need to turn over. That, and finally, they're going to talk a little bit about the grand jury standards, but I think that will be argued much more at a later date.
And I do want to ask you about that as well. So in light of these conversations, Joshua, Kohberger's trial, as you know, it's set for October. Is that likely to happen?
I don't think so. I think what we're seeing right now is the defense setting up the idea that they are going to make the argument we don't have the tools that we need to properly defend this case. This case is huge. It's not only are we involved talking about 4 different murders here, but just the magnitude of it, and also the national coverage of it is just going to add to the size of it. And I just don't think there's any way they could possibly be ready in that time, especially when we're dealing with a death penalty case. I think they're going to ask for more time. I think they're going to blame that on the idea that the prosecution is not being entirely forthcoming with all of the evidence that they have. But even in spite of all of that, I can't see them proceeding forward on this at the timeline that they currently have set.
All right. So what do you make of the defense's argument that there was a possible error in the grand jury selection process?
You know, this is kind of a typical attack. Grand juries are very frustrating for the defense because it's a hearing where they're not a party to it. It's where the prosecution presents the evidence and essentially has to wear 2 hats. They have to present evidence on behalf of their case to show to the grand jury why they believe there's probable cause to hold this person to answer at trial. But they also have to present some exculpatory evidence so that they're giving the jurors a full picture of what took place. But the defense is not present. They don't have the ability to cross-examine. They don't even have the ability to be able to present their own case. So it's typical for them to get these indictments afterwards and then begin to try to chip away at it. They're going to say that the selection process was somehow flawed. They're going to say that the standard of proof was somehow flawed. I'm not trying to be so dismissive, but I'm just saying that this is sort of typical, par for the course, and I don't imagine it's going to get them much anywhere with the judge.
Do you think the judge will demand the prosecution share at least some of the evidence, especially when it comes to those DNA results?
I actually do. I think that the judge is going to say, listen, you're the stewards of the evidence here. You have it all, and it's not up to you to decide what's important to the defense and what is not. They're allowed to go through that evidence themselves and say, hey, we've taken a look at this and we've decided that this is somehow important to the way we're going to construct our defense. And it's not up to the prosecution to say what the defense should be. In other words, they have the evidence. Aside from a few small exceptions, they really should be turning over everything. I understand the prosecution's arguments when it comes to the privacy of some individuals and not getting into the idea of red herrings and third-party culpability, but I think it really is incumbent upon them, and I think the judge will rule that they have to turn over more than they already have.